We're gonna put you on speakerphone.
Yeah.
Can you hear me, Mark?
Yeah.
Okay.
Like double. And 3 notifications came up in the same meeting, and I wanted to know. It's like not, right?
I have this long thing, are we just gonna submit this for records? Or you read, it's a line by line, replace this with some change that. Stop.
I mean, if it's beneficial, then you can summarize it in other ways.
Yeah, I can summarize it, say there's, well, change this. I will take it under consideration. If you only survive it's a new thing. They're gonna be compliant with taking it.
All right, we're gonna call this back into order here. So I'll look for a motion and a second to start the public hearings.
So move. Second.
All right, got a motion and a second. All in favor? Jack?
Aye.
Aye. Opposed?
Roll call.
Mark would like roll call.
Roll call. All right.
Hilmer?
Aye.
Public hearing,
What's that?
roll call vote for public hearing.
That's what we're doing, sir.
Hilmer?
Aye.
Knibble?
Aye.
Dolan? Kupka?
Aye.
And Turner.
Aye.
Okay, so we are in the public hearing for the settlement on Salt Creek, Wind 2. So again, some housekeeping, since some people got here a little bit later. We're gonna go through the list. If you didn't sign in, we'll take more names afterwards. If you had not spoke yet, it cannot pass your time to anyone, so you get 3 minutes per person. We do have, Mark informed me there's a representative from Salt Creek Wind that wants to go first. We will give 10 minutes to that individual, as well as if Eric Updegraff, our lawyer, gets on, we will give him 10 minutes as well. Otherwise, we can speak as well as board members here to fill everybody in on our points of view. But it's ultimately going to be a hearing, 3 minutes per person, come up to the podium, share your thoughts. Be about it. Yeah, make sure you got a microphone. We'll maybe just set that microphone there. Set the microphone there. And we'll go through the list here. And then we'll do online comments afterwards as well.
Just as a point of order, Heather, could you just reiterate that there's, questions are going to be a little bit harder to answer, so if you have a statement, just make the statement.
Yeah, we won't be able to answer all the questions since it's a public hearing. I mean, if it's basic things, and also to add into, just like our public comments, speak to the board, make sure comments, there's no profane, obscene, slanderous, language as well. So with that, any questions, concerns, we'll get started here. So to start, Kelly Orton, we'll let you come up, and again, she'll get 10 minutes here, and then everybody else will be free unless Eric Updegraff gets on. No louder.
It's on.
Hello, can you hear me now?
Yep.
Okay. My name is Kelly Orton, and I'm an attorney at the Brown Winick Law Firm, and I represent Salt Creek Wind 2 LLC. Thank you for your time this morning. I'm here to share with you the details of the Salt Creek Wind 2 project and the proposed development agreement before you here today. The Salt Creek Wind 2 project has been in development in Tama County for several years. The project consists of a 100 megawatt wind energy generation facility in Tama County. The project will include up to 27 wind turbines and related infrastructure, including access roads, meteorological stations, a project or collector substation, and collection lines to transport the electricity generated from the turbines to the project substation. The project will connect to the grid at the Toledo 161 kilowatt substation owned by ITC Midwest. Salt Creek Wind 2 LLC has obtained voluntary lease option or first option agreements for running it will be a fraction of this acreage. Many considerations went into selecting Tama County for this project and the project site specifically. The project developers evaluated many factors, including but not limited to the topography of the site, wind resources, available turbine technology, and Tama County setbacks when determining the proposed site layout, as well as turbine spacing and environmental, aviation, sound, shadow flicker, and subterranean constraints. Salt Creek Wind 2 submitted its application for a conditional use permit in December 2024 based on the wind ordinance in place at the time, originally passed in 2010. Notably, the application was submitted before the Board of Supervisors passed the resolution imposing a moratorium on wind energy conversion systems on January 6, 2025. The project was designed with the 2010 ordinance in mind. The project meets or exceeds each requirements of the ordinance. I'd like to quickly walk through those provisions now. Article 19, Section 1A, color and finish. This requirement has been met. The project will use materials, color, and texture that blend the natural setting and existing environment. The turbines will remain in their factory finished color, a non-reflective and unobtrusive shade of white. Article 19, Section 1B, tower configuration. This requirement has been met. The project will use self-supporting tubular steel towers. Article 19, Section 1C, lighting. This requirement has been met. Project will be lighted in accordance with the requirements established by the FAA. The development agreement further requires that ADLS be applied for and, if approved, installed on the project after construction. This is above and beyond what is required by the ordinance. Article 19, Section 1D, signage. This requirement has been met. All sign requirements will be followed. The turbines may show the manufacturer's or owner's name or logo on the generator compartment, but will not include any advertising. The agreement has been met. All collection lines and communication lines for the project will be buried to a depth of 40 inches or greater. Article 19, Section 1F, waste disposal. This requires a spill prevention, control, and countermeasure plan will be in place for construction that will meet or exceed the Tama County Health Department requirements and all state and federal standards. Section 1G, minimum ground clearance. This requirement has been met. Salt Creek Wind 2 has not finalized its model selection for the project at this time. The final model used will have a ground clearance of at least 75 feet. Article 19, Section 1H, signal interference. This requirement has been met. Salt Creek Wind 2 has undertaken broadcast communication studies as provided in appendices Q, R, S, P, U, Y, and Z of the application to evaluate potential impacts on radio, off-air broadcast TV, communication towers, phones, microwave paths, and emergency services. A summary of each of these studies is included in the application. The turbines have been cited to minimize interference with electromagnetic communications based on these studies. Article 19, Section 1I, Federal Aviation Commission. This requirement has been met. A DNH will be obtained for each of the turbine locations in May of 2025. These will be provided to you today. Salt Creek Wind 2 will construct the project in compliance with each DNH. As previously mentioned, the development agreement further requires that ADLS be applied for and, if approved, installed on the project after construction, which is, again, exceeds the requirements of the ordinances. Article 19, Section 1J, Electrical Code and Standards. This requirement has been met. The project has been designed to ensure it is in compliance with all applicable provisions of the National Electric Safety Code, the American National Standards Institute, the Institute of Electrical and Electronics Engineers, and the National Electrical Manufacturers Association. Article 19, Section 1K1, Structure Setbacks. This requirement has been met. All turbines are located at least 1,246.6 feet from the nearest residence, school, hospital, church, and public library. 1,246.6 feet is equal to 2 times the height of the tallest turbine listed in the application. In the development agreement, Salt Creek Wind 2 further agrees to site turbines no closer than 1,500 feet from non-participating residences. This exceeds the requirements of the ordinance. They also agreed to offer good neighbor agreements to any non-participating landowners within a half mile of a turbine if they're not already participating with a neighboring project. Article 19, Section 1K2, property line setbacks. This requirement has been met. No turbine will overhang a property that does not have an existing easement. The project was designed so that all turbines are located at least from the nearest non-participating property line, to ensure that no turbine will can be used. 19, section 1K3, public right of way setbacks. This requirement has been met. All turbines are located at least 703.78 feet from the nearest public right of way, railroad, power line, and non-occupied structure. 703.78 feet is equal to 1.1 times the height of the tallest turbine listed in the application. Article 19, section 1K4, communication and electrical line setbacks. This requirement has been met. All turbines are located at least 703.78 feet from the nearest above ground public electric power line or telephone line. Article 19, section 1L, noise. This requirement has been met. Salt Creek Wind 2 has agreed on the development agreement to a noise level of 50 dBA for any non-participating residents. This is more stringent than the 60 dBA limit in the ordinance. Appendix M contains the noise study commissioned by Salt Creek Wind 2. The noise study is a conservative estimate using maximum noise generating conditions and studying 31 turbines rather than the 27 included in the application. The noise study shows that the noise levels from the turbine will be below 50 dBA at all participating and non-participating dwellings. In the unlikely event the project exceeds 50 dBA, the development agreement sets forth provisions which would allow for this to be resolved in a timely manner. Article 19, section 1M1, safety. This requirement has been met. All collection lines and communication lines for the project will be buried to a depth of 40 inches or greater. Article 19, section 1M2, safety. This requirement has been met. All proposed turbine models are designed so they are not climbable for the first 15 feet above the tornado. Article 19, section 1M3, safety. This requirement has Article 19, section 1M4, safety. This requirement has been met. All designs will be installed. Article 19, section 1M5, safety. This requirement has been met. Consistent with the development agreement, the certification from a qualified engineer will be provided at least 60 days prior to commencement of construction, once final turbine model is selected. Article 19, section 1M6, safety. Guide towers are not expected to be part of the project at any time. Article 19, section 1N, discontinuation and decommissioning. We've broken this requirement into 3 sub-requirements for ease of review. Requirement 1, all CUX and accessory facilities shall be removed to 4 feet below ground level within 180 days of discontinuation of use. This requirement has been met. The updated decommissioning agreement attached to the development agreement provides that upon decommissioning, all facilities related to the turbine will be removed to a depth of 4 feet. Requirement 2, each CUX shall have a decommissioning plan outlining the anticipated means and costs of removing CUX at the end of their serviceable life or upon becoming a discontinued use. This requirement has been met. Via the development agreement, Salt Creek Wind 2 has agreed to enter into a decommissioning agreement providing more strict requirements than the decommissioning plan included in the application. The new decommissioning agreement includes additional protections for the county that are not required in the ordinance. Requirement 3, the cost estimates shall be made by a professional engineer licensed in the state of Iowa. The plan shall also identify the financial resources available to pay for the decommissioning and removal of the CUX and accessory facilities. This requirement has been met. The development agreement requires Salt Creek Wind 2 to provide an updated estimated cost of decommissioning the project every 3 years, beginning 3 years after commencement of commercial operation. This exceeds the requirements of the ordinance. The results of the estimated cost must be provided to the Board of Supervisors and county, and the bond must be adjusted accordingly, ensuring the county is as protected as the project progresses in the future. Article 19, section 101, roads. This requirement has been met. As part of the development agreement, Salt Creek Wind 2 will enter into a road use agreement, which requires Salt Creek Wind 2 to identify all roads to be used for transporting project components for construction, operation, and maintenance of the project. The road use agreement exceeds the requirements of the ordinance. Salt Creek Wind 2 will also obtain all required ministerial permits for the project as required for construction. Article 19, section 102, existing road conditions. This requirement has been met. As part of the development agreement, Salt Creek Wind 2 will enter into a road use agreement, which requires Salt Creek Wind 2 to conduct a pre-construction survey and requires them to be responsible for ongoing road maintenance and dust control measures as identified in the road use agreement. The road use agreement exceeds the requirements of the ordinance. Article 19, section 103 drainage system. This requirement has been met. Salt Creek 1-2 has committed to remedying any adverse effects on duly established drainage districts. Article 19, section 1P, required financial security. This requirement has been met. 130% of the estimated cost of Salt Creek 1-2's restoration obligations be posted prior to commencement of delivery of the turbine components. Article 19, section 1Q, submittal requirements. I was going to go through all of these, but given my time constraints, I'm not going to do this. I'm going to skip to the end. That's all the requirements in your ordinance. We've met all of those. In addition, the development agreement includes even more restrictions that are included in the ordinance, as described above, and provides additional safeguards and protections for the county, some of which don't exist in the current ordinance. For example, the development agreement also imposes a flicker requirement on the project, requiring Salt Creek 1-2 to use curtailment measures for any residences experiencing more than 30 hours of shadow flicker per year unless waived. Finally, the development agreement requires Salt Creek 1-2 to make a $1.2 million payment in addition to taxes to Tama County once certain conditions are met. This is in addition to the annual tax payments under the wind assessment ordinance. Rather than spending money on costly litigation, the development agreement provides an influx of money to the county, allowing the supervisors to use those funds for the betterment of the county. We ask that the county approve the development agreement and bring this to a conclusion. Thank you for your time, and I'm available for questions if you have any.
All right, thank you, Kelly. Okay, next up is Al Shapewell.
Good morning. My name is Al Shapewell. I address the Tama County Board of Supervisors.
We can't hear back here.
Is that all?
It's on.
Just gotta hold it close to your mouth.
Good morning. Here now?
You see it?
It's better when you get close.
Okay. The Tama County Board of Supervisors, and I know that the Tama County Board of Supervisors went to court against Salt Creek and fought the first looking out for and tried to help Tama County. That was a difficult case to win, and we had construction permits already original for the 6-inch turbine. Losing it was only one loss, but that agreement doesn't affect anything for Salt Creek Wind 2. Now I see documents from the Board of Supervisors that indicate a settlement agreement, the decommissioning plans, the maps of locations. In the Salt Creek Wind Energy, it's a new entry, and does not have anything to do with the permits for construction. You also have a moratorium on new wind and power construction that was in place after the Salt Creek division permits were in place. And there is no permit issue, and I don't think any permit should be issued for this. Thank you very much. Thank you for the comment.
Thank you, Al. Next up is Karen Murray.
Yeah, that's just as a point, I'm supposed to be reading the comments online. I'm not going to read it, but Melanie Roche wishes to get in line again.
No, you can before.
Okay, yep, I can add her to the list here.
I take that personally, did we walk up here? Hi, I'm Karen. So these companies, are in lawsuits for non-payment once they leave the counties. And, I mentioned this before, and it's still a concern of mine because I'm old and because we are being taken over from within without a shot, being fired at our parents taught us. And bankers and loan institutions was a real deal. A lot of people in here, they were 5 years old in the 80s. These turbines do not have finalized heights, their locations are moved, but nobody knows that because we are not allowed to go out there and research and have access to those properties. Nobody is going out to investigate. they are permanent fixtures on the land, whether they are in the correct farmer field or all over the adjoining land, where no crops will be able to be sold if we have another 2020 event, which we will have. As evidenced by all the current hard surface gravel roads, this county cannot afford road maintenance on hard or gravels. And I've asked before if these companies are anteing up for all of the gravel and hard surface road maintenance and repair, and I guess not, because we just spent a half an hour this morning talking about that situation. And yes, these culverts and bridges are being rebuilt because the current situations will not allow access for the new phase 2 expansion. They can't drive on them. The roads are not ready for them. We subsidize these turbines, but all the electricity is sent away. And if these companies were an honest and good reputation company, like we try to be in the heartland of Iowa, these contracts would not be gag orders, which they are. And these companies would not leave, which they're going to leave Tama County as soon as they're done. And we're going to be stuck with all of this stuff with no place to go and nobody to call, because that's the way it is with companies. You can't get rid of them. So I thank you for your time, and I hope you reconsider taking this to the Board of Adjustment and continuing on with our fight. Thank you.
Thank you, Karen. Next up, Richard Art.
I suggest you get the next person behind me so that it can take less time.
Yep, Jody Bolt will be the next one up.
Okay. My name's Richard Art. I live in Dayton. Since what Salt Creek Wind 2 is asking the board to do is to change Tama County ordinance by bypassing the Board of Adjustment. I Googled, are supervisors allowed to bypass ordinances in Iowa? They are not. They cannot change the process of an ordinance that is in place. Once Salt Creek Wind 2 either receives or rescinds their cups from the Board of Adjustment, then the supervisors will become involved and decide whether or not that decision is what they want to have happen. Excuse me. Salt Creek Wind 2's agreement looks exactly like Phase 1's agreement. Who wrote them? Does anybody have an answer? I'm strongly suggesting that you guys follow Iowa code. Allow the ordinances in place in Tama County to work as they should. Salt Creek Wind 2 does not have a cut like Phase 1 did. Phase 1 and Salt Creek Wind 2 are two totally different situations. And until Salt Creek Wind 2 receives their cut or a refusal from Board of Adjustment, you guys need to sit back and wait. Once that Board of Adjustment makes that decision, then you guys need to vote.
Thank you, Richard. Jody Bolt is up and Laura Wilson will be on deck.
Morning, I'm Jody Bolt, 210th Street, Gladbrook. I'm in the shadow of the Vienna Towers. Just recently, I had a decimal meter on my phone and went to the end of my driveway. One time at 9 o'clock at night, no other ambient noise. All the readings were above 60 decibels. Some as high as 82. I went 3 days later in the morning, the wind was approximately 5 to 8 miles an hour. And once again, none of the readings were below 60. All anywhere from 68 to 82. I was never approached by Vienna with a good neighbor, anything. So I am worried about the neighbors that are going to be in the Salt Creek 2. um, area. I'm sure they're gonna have more noise than what I've got. The towers are 2 to 3 times as tall. And, for Tama County, I don't know where the dollars have gone as far as tax dollars, but I'm sure everybody else's taxes have gone up since the Vienna has been in. And I'm not seeing any benefit from it, so appreciate your help at this time. Thank you.
Thank you, Jody. Or Wilson, Nancy's is on that.
Laura Wilson from Dyser and also zoning administrator at Plain County. I stated most of my concerns last week and none of those opinions have changed. I would like to stress that nothing has been permitted yet for this project. And with no permits given and no ordinance changes, I still believe what Heather said last week, that the cost of application should not give an expectation of vested rights. And any additional expenses they claim would have been done at their own risk by incurring the costs without an issued permit. Signing this agreement would give them likely those vested rights. Neither this public hearing nor the public forum are posted as being an application review. Both were said to have been an opportunity for the public opinion to be heard. However, since Ms. Orton listed all the ways that they are complying with the ordinance, I wanted to reiterate the list that I gave you previously where they are not complying with the ordinance. And as the ordinance states, submittal requirements defined for conditional use permit applications must submit the following information. So part 1G, ground clearance, no model is confirmed in the application to verify compliance with the ground clearance. 1J, electrical codes and standards. At this time of final decision on which standards for specific turbines and related equipment to be used will be provided once the final decision is made as to the model. The model is required as in the application per ordinance as shall comply at the time of application, not shall comply by the time the building permit is issued. Part 1M through 1MV and part 1Q6. Safety and submittal requirements. Per the ordinance, they state engineer certification as required in these supplemental standards. Salt Creek Wind 2 cannot furnish the engineering certificate required. 1Q4, the ordinance states applicants must submit that the items specified and model need to be selected to comply with this section of the ordinance. Type, nameplate generating capacity, tower heights, etc. Documentation of landowners in Q7. From the appendix B maps, there are 4 parcels outside the project boundary where they have not submitted proof that they have leases. And Q15, description of potential impacts to all nearby CWEX. They did not specify anywhere the impact that Salt Creek 1 would have on their project or vice versa. There should be no expectation by the applicant for the county to waive the ordinance or CUP submission requirements. And have any additional application materials been submitted since that initial application? I have not seen anything, and as of last week, it didn't sound like you received any. I had mentioned that with that lack of submission requirements, it may be a gamble to go to the Board of Adjustment, and their next step was to come to you for negotiation. I strongly urge you to send this to the Board of Adjustment instead of going through this process with the agreements. Thank you.
Thank you, Laura. Nancy Yuska is up and Doug DeVore is on deck.
Morning, Nancy Yuska, Buckingham Township and current chair of the Board of Adjustment. I won't take much of your time this morning, but I did want to say that I agree with the statements Laura has been making recently in regard to the proposed settlement agreement being discussed today. The Board of Adjustment has not scheduled a public hearing on the December 2024 CUP application from Salt Creek Wind 2 because of the moratorium resolution you passed on January 6th, 2025. And now appears you are exempting this phase 2 project from the moratorium. And in the normal course of action, according to our own ordinance, as well as Iowa Code Chapter 335, the Board of Adjustment would now proceed to have a hearing. The proposed settlement agreement states, quote, Salt Creek Wind 2 has met or exceeded the requirements of the CWEX ordinance. The copy of the CUP application that Laura graciously copied for each of the 5 board adjustment members, 3 and minor. The application consists of the introduction, overview, project description and design, project diligence and studies, submittal requirements, conclusion, as well as a list of appendices that total 26, A to Z. My question is, which one of the 5 of you has read through the full CUP application and appendices to affirm to the public that the statement in this settlement is accurate, that all of the requirements of our ordinance are either met or exceeded? You yourselves appointed 3 of the 5 current Board of Adjustment members since January, and with all due respect to your recent comments regarding your intent to protect the 5 Board of Adjustment members, I ask that you let us proceed to do the job we agreed to do upon our appointments to this board. Let's continue to read the maps, reports, survey results, analysis and assessments included in the CUP application, and have a Board of Adjustment public hearing and a vote.
Thank you, Nancy. Doug Dvorak is up and Lawrence Kushak is on deck.
Thank you. I'm Doug Dvorak, zoning board member. I've got a couple members here with me. I want to start out by asking how the 2 negotiators could have agreed to an agreement like this. It's full of holes. It's full of a lot of holes. The first one that I want to point out is on page, not the first one, but one of many. Page 4 under I. Basically says that the county is responsible for any expenses associated with any kind of disagreement or any kind of challenges. That's the county, not South Creek 2. Favor of turbines or not, this is not a good agreement. I've got more. I showed this to Rob Wobeater, our appraiser and real estate man, and he agreed with me. He commented on several places in there that's wrong. I don't know how you could call this an agreement. You're not protecting the residents of Tama County. You know as well as I do, our first speaker here is quoting, we've satisfied this agreement, we satisfied this. It's 15 years old, people. It was 2015, 2010. How many times do you deal with ordinances that are 15 years old? You've known for a long time that we have been planning on meeting and doing the WEX. We got the industrial solar done. We've already had 1 meeting on WEX. We're having 2 in the next 3 weeks, the 10th and the 17th. Show a little patience. In July, Trump said that there's no more subsidy. Our money, your money, everybody's money here. I don't do Facebook, but I happen to look at my wife's Facebook, Mr. Dolan. I hope you're listening, Mark. And you tried to make yourself a conservative for Tama County. There's nothing conservative for Tama County in this agreement. I urge all of you to vote no for it. Thank you.
Thank you, Doug.
Do you want me to respond back?
Doug, you want Mark to respond to you or no?
Sure.
Sure, he says.
Their application came in under the old ordinance, so I don't understand what your contention is with the 15-year-old ordinance.
I didn't hear him.
He said that their application came in under the old ordinance. What's your contention with it?
That it's 15 years old and you haven't given us a chance to update it.
He said it was 15 years old. Just get it updated. We've known this.
Yeah, but their application is under the old ordinance. I think all of us agree on that.
Does an application give them a permit to do anything they want?
He said, does
Strictly an application.
an application give them a chance to do whatever they want? It's just an application.
Yep, I can hear him, Heather.
Okay, sorry. I wasn't sure you're at the back of the room, so.
That's the point. I mean, he was making the point that the ordinance is 15 years old. They need to get a new ordinance. However, this application came under the old ordinance, and I believe that we would all be in agreement that they're filing their application under the old ordinance.
Okay. Go ahead, Lawrence.
Hi, I'm Lawrence Hushak. I live on Martin Township. My mother signed up 12 years ago, and I don't want it on my property. There has to be a statute of limitation on it, at least 10 years. And that's one thing. The next thing is I talked to a lot of farmers they have new implements now that subsoil is down 36 inches. So these power lines that are being dug under the ground are only 40 inches deep, okay? In 1970, REC came out and they started burying all their high tension wires underground. After 5 years, frost, water, and lightning destroyed the power lines under the ground. So that's an issue for me. And another thing is with taxes on this proposal. If they go broke after 4 years, it's kind of on the average for their companies, 4 years, and then they'll channel it to Alliant or whoever is the power company in charge. And then, so are we gonna get stuck with the property owner that owns the windmill? Are they going to be stuck with the property tax on that? Now, if he was like a 2% tax on $1,000, that'd be $80,000 per year. Okay, so that's something to think about. That's what I've been thinking through my mind. Who's going to pay for all of it? And lost my train of thought.
Yeah, 1 minute. You can think.
Okay. Yeah, so if they've got rivers that go in 36 inches deep, we've got only 3 inches of all these lines clearance. So what are we going to hook them? And so then they're going to go in with, if you give them the wind rights, you can't build bin, trees, or anything else, anything or silo. Yeah, you can't. It's a non and void. And you also give them the rights to, if they put a power line in your ground, then they can go in anytime and trace it and rip up the soil. And there's more things, but that's all I got right on my top of my head. So thank you for your time.
And Larry Bouchard is next after that. Yep, you're next, Lynn. Yep.
Grab the microphone, please.
Don't take a microphone. I'm going to have the courtesy to face the people that are here for the hearing.
You're gonna need to use a microphone so that everybody can hear, sir. Please use a microphone. Please use a microphone. Right there.
Right
there. Right there. I don't want you to, I want you to be heard, but you need to use the microphone.
I'll yield to the next person.
Okay. We'll come back to you, Lynn, if you want to finish up there. Leonard Hushak is next, and Linda Bowler on deck.
This way. I'm a little long-winded, but I'm get up here to talk about this kind of stuff. I think about this windmill business. Basically, you're polluting out of a farm ground. It's a big pollution thing. You look out there, you see them damn things are swinging in the wind. No, that's a big no-no. And us farmers, we're falling for these carrots. They ain't a carrot, and they fall for this thing to get $10,000 a year, whatever it is. We're signing away our rights. We, like Lawrence was saying too, can't put a tile line in, you can't build a building, you can't have streets. I mean, we're signing our life away, and even if you sign for something like a wind right or something like that, well, your right has just been taken away. But what I'm saying is, the short this nuclear business is coming up. Trump is against all this windmill business anyway. This is it's just something for the right now, and that's all it is. So another thing we can do probably is we've got big cities. A lot of our electricity that's generated through this doesn't go here. The farmers don't get any of it. Why not put some solar panels on some of these buildings that are looking New York? I mean, you've got big cities. I mean, windmills you can't put on a building, I'm sure, but solars you can. It's just another way of producing electricity. But the thing about electricity too, there's on this windmill thing too. I talked to a lot of the guys at Lion. Those things are so doggone high maintenance. And then we're supposed to have cheaper electricity. We're supposed to have cheaper electricity. Well, it's not. Our electricity bills are going up and the windmills are going up. Where's the cheapness coming in at? I don't understand that at all. So, I'm an electrician. I like electricity, but this is not the right way to produce electricity. We got a lot of coal and they're trying to go with clean energy. Well, that's a big cop out really, because it's just another way of this as far as clean energy and all that stuff. But anyway, that's kind of where I think about this thing too, but just it's not good. And it's like I say, it's pollution. Light pollution is what it is. And it's not even smart. It's dumb. Farmers, here's the carrot, here's a few dollars, but here they got $15,000 to $20,000 an acre land. So that's cheap. I think that we should get about $100,000 for each one of these darn things. And then that land is being taken out of production. Well, we're losers, just losers, all we are.
Thank you, Lawrence.
Leonard.
Sorry. Next is Linda Moeller with Jim Smith on deck.
Good morning. I can't do as well as he did, but I appreciate the people that are speaking up and voicing their concerns. The very first page of the draft agreement speaks about the moratorium and what the zoning board has not done. Well, we know that the zoning board worked weeks and weeks and months to get in the solar ordinance, and they are working on the wind ordinances now and have put in extra time to try to move ahead with that. I think that comment in the draft is also very kind to the zoning board and the work they've done. Also, I haven't seen anything on the draft about signal interference. If it's there, I didn't see it. The county has spent millions to do the E911 system. And the company has reportedly agreed to remediate any issues. And so that should be in writing with the agreement. Also, it's my understanding that nothing has been permitted in Tama County for Salt Creek Wind 2. So why does it seem like this agreement is being pushed through without following numerous ordinances? I appreciate the work that Supervisor Heather and Zoning Administrator Laura did to review the ordinances at last week's meeting. These concerns need to be addressed. We need to close the loopholes. And this past week, I saw a video of someone concerned with their land in Indiana. He showed a video of the cornfields, showed a video of the bean fields, and then here's all these wind turbines. And, we know, what it does to the landscape, which is kind of minor in what it does to the land. They said that all of the energy went out of state. We know that's the proposal here too. We don't get any benefit from the wind energy. And their energy bills in the area had doubled. Nothing is helping us in that way. Thank you.
Thank you, Linda. Jim Smith is up next and Barry Gilbert is on deck.
I request this, and I'm while I do that.
Yes, sir.
Thank you. I'm not in favor of Salt Creek 2. And I don't want any of the landowners to get hurt by this, especially the ones that are signing up and have signed leases. And I would assume they're a 35-year lease. I don't know. Kelly, I think Kelly's back to verify that. But this is a long-term lease. And the high lines there, that the electrical wires, high voltage electrical wires are they won't put them any deeper than they have to. So that'll be roughly 40 feet or more. But so if they're locked into a 35-year or more contract, how long does their tiling last in that field? I would assume that they lease like 40-acre or 60-acre parcels, like Salt Creek 1. And if they want to tile that field, I imagine they have to get permission from the owner of Salt Creek 2 to do that. And for the last 35 years, I talked to Tyler a couple years ago about this, and he said, if you're on a tiling machine, of course, today maybe they have autonomous tiling machines, I don't know. But if you're on a tiling machine and you're putting in tile and your spade, it's one of those wires. That was his response. So I don't think these farmers are able to do much tiling if they can't find anybody to do work for them. What else did I don't know if there's anything.
All right, thanks, Jim. We got Gary Gummer is next and then Kurt Burns on deck.
Thank you. My name is Gary Gilbert. I'm just a small landowner. I've only got less than 3 acres. And I'm not one of these big farmers that have a lot of thousands of acres. But I'm also very, very, very concerned about the location of where these turbines are going. I've got one on this plat map, less than 1,000 feet from my house. And I thought I just heard that according to the Iowa code, they have to be 2,000 feet. What I heard just recently. So if it's 2,000 feet, they're in violation of their own code. So let's get right down and not approve this. Thank you very much.
Thank you, Gary. Kurt Burns is up and Carolyn Adolphs is on deck.
Morning. I, along with many others in this room, actually, they're not in the room, they were forced to stand outside mainly. Am a agricultural property owner in Tama County. That land is our business. It's our livelihood. Private property rights allow us to run our business as best we see fit, to make a legal, ethical profit. It's our property and our rights and our business. What TCAB members want is to control the use of my property, but give no legitimate reason to do so. They want no ground with CSR ratings above 60 to be used for anything other than row crops.
And beans with a 9 in front of it. Once you subtract inputs, farmers are losing money with every acre and have so since 2022. TCAT doesn't care. TCAT does not balance any other economic factors. Fact is, wind turbines provide a much needed diversified source of income to pay the ever increasing county property taxes, which if you opened your envelopes last month, you see they are not going down. And keep my family farm a family farm. It's a means to keep family farms in the family because of the income from a different source than corn and soybeans. Allows it. It's steady. It's every year. You can count on it, and it increases with inflation. It has an escalator. As a business owner, I have the right to diversify my income using legal means. This is not a decision anybody should surrender. TCAT wants to overregulate Tama County businesses. That is illegal. And it is known as confiscatory in the law. That means it's similar to confiscation of your land. TCAT proposals restrict the use of private property to such a degree that it effectively amounts to a government, quote, taking. This is against the Fifth Amendment of the U.S. Constitution and will require the government to pay what they call just compensation in order to do so to the property owner. In other words, what will happen is there will be more litigation if this isn't settled here. TCAT would significantly interfere with the Tama County property owners' reasonable expectations on how they use their property. When the property owner made their investment, this policy was not enforced as a ban against property rights. When most anyone in this room bought their property, TCAT was not in existence. Before TCAT, we as property owners had a right to make very significant amounts of money. It may not seem like much to some people, other people, it may be a lot of money. This is a change that will bring about more unjust changes and restrictions on the use of our farmland. The public purpose to save farmland is not a good enough reason. Focus is on the burden placed on individual property owners. The core principle is preventing the government from allowing a group like TCAT, forcing a few property owners to deal with CSR land bans and make them bear the burden to save farmland when the inclusion of wind turbines actually save more farmland than the outdated CSR statement. The ugly truth is TCAT does not care a bit about the family farm or the community. They just don't want to see wind turbines property that they don't own. Thank you.
Thanks, Kurt.
Randy Smolik, speak, if you want to add him in, Randy Smolik.
Carolyn Adolphs is next, and Mark Burley will be here.
So I had a lot of things to say, and I don't have much time. I'm gonna respond. You own land as a farmer. I own land. I'm in the Geneseo Township. We own land, but we own land. How far up in the air do we own land? You know, do we own land from here or do we own it 500 foot in the air? When it's 500 foot in the air, then that's everybody's seeing that. So, I really, and I live outside practically. I have market gardens. I sell in Waterloo. And if this would be around me, it would drive me nuts to hear this, to see it. It would just drive me nuts. But if it was on your land, fine, but it's not. It's way up in the air. That's a whole different story. I think we're getting used in Tama County. We've got this project coming in, we are getting used. And then we had an agreement now with Salt Creek. We'll get $1.2 million to use for Tama County rather than getting sued. Well, what's that? That's not maybe 80 acres or 100 acres. That isn't that much. I'm willing to pay money to stop this. And I don't know, because this is hurting rural. This really isn't hurting the towns around here, but it is hurting the rural area. And so I would really like this to go in front of the Board of Adjustment where it should go, rather than some other agreement. Thank you.
Thank you, Pam. All right, Berlin will be there is up and on deck is Andrew DeBorak.
So I'm given 3 minutes to talk, and this, wind project could be in my neighborhood for the rest of my life on the farm, so I'm not sure 3 minutes is fair. So our farm and home is part of in the middle of phase 2 turbines. And when I heard there was a phase 2 settlement being considered, I of course was interested. What was being settled? With whom was it being settled? What were the terms of the settlement and who initiated the settlement? In the years since the conversation of developing wind energy in Tama County first started, there has been much that has changed. And most notably, for better or worse, communities have been more resistant to wind development. And that makes sense. There's been more experience, much more has been learned. And as people have reflected on it, they have not always been happy or positive about wind energy development. On the other hand, there are those who have been unwavering in their support of wind, and they want a turbine, and they have not changed on that. And some of us have said, no, we don't want one, and we have not regretted that decision. When I first read the settlement, I came away thinking it was very heavy-handed, favoring the interests of the wind companies over the interests of Tama County. So point 1, if the tone and acceptance of wind energy development has grown more negative in the intervening years from the idea of implementation, it is not our county's fault. This wind energy company has taken many years to bring this project to fruition, and things have changed. And so for a company to respond with heavy-handed tactics and attitudes is just plain disappointing. We will live with this project for many years, and we will experience the ramifications, and we do not take that reality lightly. I believe very strongly the company and Tama County should have a respectful relationship in this process and not be heavy-handed tactics. Secondly, I am beyond puzzled by the apparent attempt to bypass the Board of Adjustment in this approval process. This board unanimously voted for every change and appointment on the current Board of Adjustment. The BOA should never be about taking sides or voting for preferences, as it is about acting only on legal facts, and everyone who is appointed should know that. If the BOA is not trusted by our 2 supervisors in negotiations, then I have to ask why and what was it that your intent was in creating the current board, and what is your intent in bypassing? Okay. That is really disappointing.
You can finish a couple sentences.
I also support Laura as the zoning administrator. She has questions. She has brought those questions forward. It should not take that long, if it has taken this many years to develop a project, to answer her questions. Again, the board hired her. You should respect the people you hire and have her questions answered. And I guess I would conclude by saying Governor Reynolds likes to promote our cheaper renewable energy in Iowa. There is no good reason to support the production of cheap energy when it comes on the expense of our land and lives. We are now asking 1.2 million. I say, when this wind company offers 5 million to our schools over the length of this project, I will believe that they have our best interest as a county in mind. 1.2 is certainly not.
Thank you, Berlin. Andrew DeBorak is up. Thank you, Berlin.
Thank you.
And Kern Coster's on deck from Tama.
Got it.
Cam.
Cam Coster's on deck.
I'm just gonna keep it halfway short. I've gone through this agreement. I agree. It's very heavy-handed. That certainly isn't in favor of the counties. And I'll show you that paragraph right there. That should be omitted on page 4, the second paragraph down there. Omitted. All you're doing is punishing the entire county. and the taxpayers. These people have money to fight this, that's fine. For or against. This needs to be cleaned up. We need to area this. There's nothing in here that's actually for the county.
Thank you, Andrea. Cam Coster is up and Jim Boosterrock is on deck.
Better check the hall.
Yeah, check the hall, either Cam out there.
Check hall.
No. Okay, we'll skip and if Cam shows back up, then we'll get back Cam on the list. So let's go to Jim Bouchard and on deck is Steve Aldrich.
Good morning. I think that my argument was stated earlier and is the argument of a lot of people here in Tama County that are not being quoted in the newspapers or on Facebook, and that is that if we want our cash crop to be wind energy as opposed to alfalfa or corn or beans, then that's our choice and that's our land, and we're not hurting anybody by doing so. If we are worried, and some people are worried about taking ag ground out of production, remember that it's a quarter of an acre or less per turbine. Building bin sites in the country. You have to quit allowing road expansion in the country. 2 months ago, someone on the board said that I am not opposed to wind turbines. However, I'm opposed to anything that basically works on subsidies. One of the supervisors. So based on that, I did a little research, about 15 minutes. Based on the Brookings Institute, $20 billion a year in direct tax subsidies from the United States government for fossil fuels. This would be tenfold if we then started working out how much it costs to clean up the damage from fossil fuels, the damage to roads, communities, food, water, and so forth. So the subsidies are part of our life. We have a lot of farmers here. You should be worried about your property taxes. Look at the tax base in Tama County. We do not have a big industry. These people are bringing us tax dollars. We should thank them, not push them out. And finally, if you're worried about subsidies, the estimate for ag subsidies for 2025 is $40 billion. We are you and I, a walking, talking subsidy taker. So let's not worry about subsidies for wind energy because they're everywhere. I urge you to strongly support wind energy expansion in Tama County.
Thank you, Jim. Steve Aldrich is up, and then we'll do the couple online that have got on the list, and then we'll go back up for anyone that hasn't spoke yet that would like a turn. So go ahead when you're ready, Steve.
Good, okay. Yeah, I'm Steve Aldrich. I could care less one way or another about wind turbines. They never come to care less. However, I think they're a necessary thing that we need for energy. I don't want nuclear plants. The biggest thing about it is my choice, my ground, my choice. Everybody else has their choice. If you don't want one, fine. The biggest thing I think we should look at is we have no industry in Tama County. We need tax dollars desperately. We're out of money. This is going to bring millions of dollars to our schools. Everybody's having to rebuild South Tama, North Tama, GMT. Rhinebeck, Gladbrook, they need to do work on their schools. They need money. We need money. And that's a big issue about this. Some of the other things, though, other previous speakers, you got to get your facts right. There are several things that they are responsible for with Salt Creek as far as the tile and stuff. They cannot deny you tile. They will fix any tile that was in it. It's in the contract. If their electrical line interferes with it, they have to pay for it. If it gets too shallow, I run across this with a gas line on one of my properties. They got too shallow. It was up to the utilities company to come and put dirt on there and get it back to the proper depth. That is not on the farmer itself. That's pretty much everything I said, other than, one other thing I'd like to say is that you can build on your building site. They're not gonna stop you from putting up a great building something. That's all I got. Thank you.
Thanks, Steve. Before we go to the two online, Lynn, did you want to speak without a microphone? I want to make sure that everyone can be heard. So if you'd like to sit there and speak, I'd like to hear your comments or stand up, whatever you'd like to do.
Yeah, thank you.
You're welcome.
I don't have the courtesy to speak to the people that came here for this meeting. Produce energy, the nuclear thing is coming back again with new technology. The wind hasn't blown for 2 days in the last month. Fossil fuels produce energy 24/7. This windmill thing is just about as much sense as going around in a circle and go through a four-way intersection.
All right, let's go on to Melody and Roja.
I see something.
Yes.
Melody, can you hear us?
Problem is it's only coming through here.
You want to say your name?
I can barely.
Barely, hold on. Can't do it.
Come back to Melody Zamolik. Online, I'd like to speak.
Hello, can you hear me?
It's really quiet.
Is it coming through the?
It's coming through, but I can barely
Coming
hear.
through, but really quietly.
Is the volume, need turned up on?
Put a microphone?
It's too quiet. You're gonna pick it up with the mic.
My mouth is just about as close.
One second here. Speak now, see if it, or hold the microphone next to the computer.
Hello? Hear me? Is that all right? I can try to talk a little bit louder as well.
Yeah, it's really quiet. Our owl's been having issues. See if we can get it working. Otherwise, you're gonna have to put your comments in the chat and then we can read them for you if, you write your comments in the chat and then we'll read that once it's in there.
Yes, and I'll.
I can read about it too, if we get them in.
Oh, yeah, okay. Yeah, Mark can just let us know once they're in there. Let's go back to the room. Anyone that has not spoken, please, that wants to in this public hearing, please raise your hand and I'll call on you. Okay, John, please state where you're from and your name.
My name's John Black. I'm from Geiser, Iowa. We talk about property rights. I didn't have a speech written up this morning or anything. I'm speaking from the heart. I think when we talk property rights, we need to talk about everybody's property rights. You know, we've heard here, my land, my property, my decision. Wrong. Try and put up a hog building wherever you want. Won't happen. It's not gonna happen, can't. Second of all, wouldn't do it anyway. I think when it comes to this, it's real simple in this county. Treat people the way you would like to be treated. The people that want these windmills, they all moved to Trier, Toledo. They're not living out there. Put up a hog building. We've got a zoning board, a board of adjustment that is in place for these kind of decisions. You can't just put up a hog building next to the neighbor. There's reasons for that. It's property rights for everybody in this county. Everybody in this county should have a voice. Number two thing, I've never seen anybody take the deed and put it in the casket. We are caretakers of this land while we were here. We're already hearing about people that my farm's getting tore up. People have spent a lifetime picking up rocks. And the dump trucks are dumping rock on them like none other. What's the point? We talk about farmers are losing money. You know what it comes down to? Living within your means. When we were approached to sign up for these turbines by an individual in this room, he said, oh, you guys ought to sign up. He said, people are buying lake homes and everything else. You know what? That land is a gift from God. The prime farmland we have here in this county. We're here as caretakers of the land while we are here. Plowing transmission lines, dumping gravel. They're going to empty the quarries around here. There's more gravel on those windmill sites than there are the gravel roads. And we talk about save our schools. Everybody's got a bond issue. What happened to Garland? Windmills in Grundy County didn't save them. The windmills at Gladbrook didn't save anybody, now did it? And like I said, I just speak from the heart. I was never brought up to take care of land like this. You're either in production agriculture or you're not. Second of all, those turbines, you want to talk about property taxes? A commercial rate. Because you know what? That is no longer farmland. That is no longer ag land. That is commercial industrial turbines. No ag rate applies to that. I think we all realize that. Thank you for your time.
Anybody else?
Yes.
Can you state your name and your city you live in?
Iowa, 1518C Avenue. Wait for the microphone. Oh. I am definitely against wind turbines 100%. It's another green energy. They have 240, they have 240 gallons of oil that runs these turbines. They're not all clean energy. They have to have oil. I am essentially farm owner. I'm a caretaker. I'm going to take care of my land. I told these green companies twice, no, they will never come see me again. Ever. It's my land. I respect it. I'm a caretaker. My neighbors who surrounds me said, Rita, I'm sorry I got wind turbines. You know why he told me that? He told me that this company's lied to him, that my whole neighborhood signed up. And they didn't. I blame him for not talking to us. That was his mistake. But if he did talk, he would never sign. And he tried to get out of it. These wind turbines, and you have the right to get out of it. You made a mistake. It's your land. It's your land. And like I said, I am a caretaker. I am steward. I will take care of my land and protect it 100%. Am I rich? Nope. Do I want money? No. Am I happy where I am? Yes. I don't go beyond my needs. I live within my means. I am happy. And I'm blessed that God gave me land to take care of. Thank you for listening.
Thank you, Rita. Point of order, if anyone's gonna have side conversations, please step out into the hall. We need to give respect to everyone, because everyone has a chance to speak. Who else would like to?
Melody's ready. Mark's got Melody.
Real quick, let's go to, Mark's gonna read Melody's.
He's got Melody on conference to talk.
Phone. Hello, can you hear me now?
Yes, we can.
Excellent. So my name is Melody Rosé. I'll give you a little background on myself. I come from farming on both sides of my family, both maternal and paternal. And my maternal family was able to retain their 150 acres in Tama County through the Depression while we lost the farm on my grandfather's side. And I would like to say that my opinions are my own and do not represent Base Acres LLC or any of my previous employers. I have a bachelor's degree from Iowa State University, and I'm working on a master's in sociology with a focus in community and economic development with a specialization in food systems and agriculture at Illinois State University. And I do not say that to intellectualize any of my comments. I say that as I care deeply about these issues, and I think about them, and I learn about them all the time. Farmers are my favorite people in the world, even though I'm not farmer myself, although I would like to be. So I served as an Miracle Vista for 2 years, running community gardens in Waters, Iowa. I worked for the Illinois Farm Bureau for 2 years, including a stint in local government. And due to all this background, I defer to much of the community opinions, but as others have one's own ability to control their land. This is a very important core tenet of the American experience. We've been able to control our land, and that includes air rights. Now, I do concur with other folks. Reading the electricity prices in Illinois, we're suffering as well. I think that any sort of project like this needs to be committed to the community that they are interested in. And possibly that could include incentives around electricity, discounts, etc. I am concerned about decommissioning windmills at the end of their life cycle. Companies run out of money, they go out of business, and they stop paying. So who is supposed to take care of that at the end of the life cycle? I'm also concerned about environmental impact, including bats. Many bats die every year due to the impact of windmills. I've forwarded sources on this to one of your board members, I believe. But ultimately, my goal and what I care about is anything that keeps farmland in the hands of farmers and farmland owners. I do not have the ability to farm the land that my family owns. I don't have the knowledge. I can't do it, you know? But whatever keeps that land in the hands of farmers as opposed to civic development, keep character, counties that I care about. Thank you.
Thank you, Melanie. Is Randy ready, or do we want to open back up to the room? All right, let's open back up to the room. Did you have something in the back here? Please state your name and where you live.
My name's Steve Gerlach. I live on Kayan Avenue in the area. And I just want to throw my 2 cents worth. I'll talk loud.
I can't hear you.
Stand right there by the wall. Okay. Yeah. So anyhow, many years ago, Salt Creek came out to our farm to stop myself and my mother. I feel I was really glad. They wanted that signature. They told me that being I own 40 acres with the homestead, that I might as well sign up because they could never build a windmill on my property. So they wanted everybody to get a little piece of the action, is what they said. So I put my signature on it. Then they wanted my mom to sign up the rest of the farm. She looked at me and goes, well, do you want me to? And the guy looked at me and said, all you have to do is where you signed up, saying there's no access to your farm from your farmstead. They will never build a windmill on it. So she went ahead and signed it. Many years later, they called me in and say, this is where we're putting the windmill. Now I own the farm. And I looked at the guy that sat out on my farm. And I said, you told me they would never build a windmill on my farm. And he goes, no, I said it would be really difficult. So in hindsight, I wish I had never put my name on there. I look at it, why do we want to do business with those kind of people? Right. I also look up a half a mile north of me, 1 mile south of me, there are nine people that live there. I feel like out of those 9, there's at least 8 that are dead against it. And they have rights also. And I apologize to them for ever signing my name to Salt Creek Wind. Thank you.
Yeah, Randy on the phone.
Thank you, Steve.
Yeah.
Go ahead, Mark, what was that?
He's got Randy.
We have Randy on the
Okay,
phone now.
Casey's gonna hold the microphone one sec.
Randy, go ahead.
Go ahead.
Hello, everybody. This is Randy Mullick. I'm a member of the Mullick Family Farm LLC located north of Toledo and in the Salt Creek 2 Wind Farm area. This is a century farm, meaning it's been in our family for over 100 years. My brothers and sisters are all members of the LLC, and one brother farms the land and lives on the farm. It started years ago with Salt Creek putting up wind vanes measured for wind speed and velocity. We were eventually selected as a site for a turbine. We had Zoom meetings, on-site meetings with Salt Creek personnel. We all, the family, reviewed the proposal, the lease agreement, and we voted unanimously to accept this so we could diversify our income and help keep the farm as a family farm, to help pay for the high property taxes, and help pay for farm bill, requires time and work that must be done. We finally, 12/7/21, 4 years ago, I'm personally disappointed that we missed out on all those years of farm income to help keep our farm in our family. Secondly, I will lead the nation in wind power generation and the model for the rest of the whole country. Watching news, they always quote Iowa as being a leader, and now why are you pushing back on that model? So I ask you to vote for the settlement and then move on to phase 2 Salt Creek. Thank you very much.
Thank you, Randy. Anyone else in the room that has not spoken that would like to, please raise your hand. Anyone else? Anyone else? Okay. Are we done?
Everybody's done.
Yep, go ahead.
All right, so I received an email from, Mr. Mulgater. And he has, I've reviewed the decommissioning plan and settlement agreement with several changes that need to be considered. The decommissioning plan, life 50 years according to the Institute for Energy Research. The average life for wind turbine is 25 years, with only 7 to 10 years before blades need to be replaced. Change it to 25 years. Foundation, change to 8 feet instead of 4. If owner wants to construct building on site, needs to be at least 8 feet. Also, insert in accordance I think that with decommissioning plan and easement agreement will not just. Easement agreement, no comment on type of removal, no blasting, use high pressure jets or maybe hydraulic hammers. Increase all 48-inch to 8 feet and decommissioning after all participation planned agreement. Access roads remove unless otherwise provided owner's easement agreement with owner. And fencing in site restoration. Summary of progress. That was crossed out in financial records. Needs to be at least 125% of total costs, only renews every 3 years. Irrevocable letter of credit can take a long time, use cash or bond, and remove but not limited to. Transfer the statements crossed out, include them. Settlement agreement, page 1, passed in 2010, changed to current ordinances. 2C, violation of this section, add Salt Creek Wind 2, actually it's just initials, SCW2. Second, 2D, change vested to contingent rights. 2E, remove or change to county can revoke, etc. if SCW2 does not follow all ordinances. 2F, erection of one turbine to all turbines. 2I, change from county expense to SCW2 expenses. 3H, needs to be increased to 1/2 miles. 3J, remove SCW2, fulfill this obligation until the ADLS is approved, and if any legal expenses after completion, it shall be SCW2 expenses. 4, duty to defend at expense of SCW2 and choice of law, remove waives trial by jury. I would want trial by jury, not by judge. Please review these as we feel these changes need to be made. And then if you have any questions, you can email them or call them. I'll give them spoke.
Thank you, David. The other two comments that we had was of individuals that are here today that spoke, Al Shafron and Gary Gummer. So unless you guys want us to read what you had wrote us, we did receive those too. Anything else online? Anything in the room that we're missing?
No, Eric got the graphic now, virtual.
Okay, does Eric want to speak now?
Sure, absolutely. Hey, I appreciate everybody having here. I apologize I was late, misunderstanding on my schedule here this morning. I just want to address, a lot of times we get questions that, hey, why are we considering a settlement agreement in these circumstances? And the answer has a lot to do with the vested rights theories and whatnot that you're going to face in any potential lawsuit relating to this. And the biggest issue that we have from a lawsuit perspective is the potential exposure for damages in these types of cases is very significant. I got a article last week from somebody talking about a similar case in Michigan where a city had an award of $59 million against it for passing zoning ordinances that were affecting people's vested rights, those types of things. When it comes to wind turbine claims, the damages maybe aren't $59 million, but they are certainly significant if you're talking about even just delay damages for a project. I mean, if they litigate with you and they are able to win and develop their project, the damages are significantly less than they would be otherwise. The biggest concern we have, and the reason that this has become urgent, is that on July 4th, 2025, Congress passed and President Trump signed the Big Beautiful Bill. The Big Beautiful Bill changes the construction timeline for federal tax credits when it comes to all of these projects. Essentially, prior to the Big Beautiful Bill, a wind turbine company would be eligible for its construction tax credits if it completed its project by 2034. Now that date is 2029. And in fact, if you want to have until 2030, you have to reach a beginning of construction date of July 4th, 2026, 1 year from now. So with that in mind, it has become a much bigger issue for us because the potential damages in a lawsuit are much bigger in a circumstance where the project can't be completed. In a world where the project is completed, again, your damages are just delay, right? If the county were to lose a lawsuit related to passing a moratorium and or passing its ordinance, then, essentially it's the question of were there lost profits for 2 years, 3 years, whatever it is took for that litigation. In a circumstance where the construction tax credits go away and the project is never built, and that's a circumstance that we all have to deal with now after the passage of the Big Beautiful Bill, the damages are are much more significant. I mean, these are projects where they estimate the cost of doing this is $2 million per megawatt. With that, or megawatt they're going to produce. With that idea, the project's hundreds of millions of dollars, and the lost profits over the life of it are probably tens of millions of dollars. That's much different than what we faced prior to July 4th, 2025. And that's the reason that settlement agreements and those things have become a much bigger issue. The other thing that has come up a lot here is in these. So anyway, that's the reason that we're considering this now, as opposed to letting the process play out. The other question that has come up a lot has to do with whether or not the Board of Adjustment is required by law to hear this case. And the answer is sort of, but not really. The idea is this: the Board of Adjustment is a zoning Board of Adjustment. It is responsible for adjusting zoning laws on a property by property basis. And in particular, it adjusts something called conditional use permits, CUPs. And those conditional use permits are defined by the actual ordinances of the county. There are no standard conditional use permits that come from the state of Iowa. Those conditional use permits come from local ordinances. So the Board of Supervisors is authorized to change what the conditional use permits would be. For instance, they could change the approval of a wind turbine project from a conditional use permit in front of the Board of Adjustment to a CWEX permit in front of the Board of Supervisors. There's several counties that do this. I know I heard last week somebody say every county does it through their Board of Adjustment. That's not true. Page County does it. Worth County did not. They had different procedures. There are a number of counties, I believe Pottawatomie County does it through their Board of Supervisors as well. And it really comes down to this discussion of how you process a CWEX permit. And the issue with a CWEX permit is a commercial wind energy conversion system permit is that it often is far beyond what you really a zoning Board of Adjustment is intended to do. Zoning Board of Adjustment is designed to essentially adjust those zoning laws when they are district by district, right? Saying, hey, this use is acceptable in the county. It's as long as it doesn't affect the zoning scheme that we have, meaning it doesn't affect the residential properties next door, those types of things. And while that's part of what happens in a CWEX permit, the other part of it is what I call the general police power, and that's borrowed from constitutional law. General police power is the ability of your legislature, which is your Board of Supervisors, to legislate for the general health and welfare of its constituents within its jurisdiction. When you have regulations on land use, some of them are zoning, like, hey, you can only build power plants in industrial zones. Some of them are general police power, like, hey, you can't build something that's taller than 500 feet because it's a danger to people. And that danger exists regardless of whether you're in a residential zone or an industrial zone. On top of it, there are public policy issues that come into play when you come to a CWEX project. In particular, you can see there's a decommissioning agreement to be negotiated. There is a road use agreement that affects more than what the Zoning Board of Adjustment is designed to deal with. And so for those reasons, there are lots of good reasons for the Board of Supervisors to consider it. At the same time, I won't criticize anybody who decides they want their Board of Adjustment to have the first crack at it as well. With that said, if the Board of Adjustment renders a decision in this case, the Board of Adjustment's decision is subject to potential litigation as well. It's not a circumstance where we just get a pass because the Board of Adjustment made a decision. And there are two types of litigation that can occur there. Number one, there's the substantial evidence legal issues that go with that decision. And then there's arguments about whether or not the Board of Adjustment acted in bad faith in making its decision. A bad faith decision there, or an argument about a bad faith decision, creates risk of monetary damages as a litigation issue. So those are the things that the Board of Supervisors have been working on to try and figure out if this is something that they want to do. Now, with all that said, all I want to do is make sure that you all understand it's not my job to tell you whether or not you have to have a settlement agreement or whether or not you need to change your ordinance or do any of those things. But I do want to make sure that we make these decisions in an informed fashion. It's not my county. I don't live in Tama County. I just want to make sure that everybody understands that there's a significant risk of a lot of damages that has a serious impact, not just on the Board of Supervisors, but has an impact on the county in total, right? If you have a judgment in your county for $5 million or $10 million, and it's not covered by your policy, because that's what these insurance companies or risk pools do in this circumstance. They will send reservation of rights letters regarding these particular claims as, hey, maybe they're not covered. In that circumstance, you're looking at things like a $5 million verdict, and you're sitting there saying, well, we're going to have to declare bankruptcy as a county. Even in that circumstance where you declare bankruptcy as a county, let's say that the bankruptcy court gives you 10 years to pay it back. It's $500,000 out of your budget every year, at least, assuming that there's no interest. That $500,000 means you're going to have to let employees go. All right. I mean, or you're going to have to make sure you're going to have to not take care of the roads or whatever it is. So that's the public policy thing that gets involved with this. And I don't say that to scare you. I say that so that you understand what the stakes are here and why the Board of Supervisors are considering these things and putting it together. The hope with a development agreement, a road use agreement, and a decommissioning agreement is to try and get a deal that compromises this situation but eliminates the risk. Now, at the same time, it is always up to your Board of Supervisors members whether they want to take that risk. And that's why they want to have public hearings and they want to hear what you have to say about it. Because again, this is the policy decision that they have to make. So I appreciate everybody listening to me talk about it this morning. I'm glad to answer any questions anybody has, but otherwise that's what I have to say about it.
Thank you, Eric.
Heather, who was that?
Eric Updegraff, he's the Hopkins and Huebner lawyer that we're currently using for the settlement on phase 2.
That's what the county's using. That's the county's lawyer?
Correct. The supervisors are using,
Yes.
It's our risk pool lawyers too, but that's who we appointed for the settlement. Yep. Any other questions based off of that?
Did Mark hear all that? Go on.
Yes, he's online. Yep. Okay, all good? Take a motion in a second to go back.
So moved.
Second.
Okay, roll call.
Hilmer,
Aye.
Nibble,
Aye.
Dolan,
Aye.
Kupka,
Aye.
Turner.
Aye.
Okay, we're back in open session. We will continue to finish the meeting up here, so that is all of the public hearing. We'll just finish it out. Anything left is public comments, if we want to do anything outside of this, I guess, thoughts, team? Public comments open up, if anybody has anything more to say after today. Raise your hand. Karen?
A little bit of chit chat back here. Maybe we need a different law firm that would be on the side of the county farmers.
Anybody else? Jim?
Yeah, farmers or grain producers have a farm or grain producers and farmer, they're concerned about raising crops and they can't make a living at it. So they're looking at an alternative source income. But there's already been a large amount of seed corn growers in Tama County that are no longer growing seed corn because Ortega has decided to move to other areas for their seed corn production. And that's a big loss in income for the Tama County seed corn growers.
Thanks, Jim.
And there's gonna be a lot more of the seed corn growers that are gone when Salt Creek 2 goes in.
Okay. Before I forget, I forgot to mention too, there is another public forum, September 11th, this Thursday night, 6 p.m. Toledo State Bank, correct?
State Bank,
In the
right over here.
community, is it called the community room?
Yes, sir.
So it'll be just right over here, not the one that's by Fairway, the one that's just right here. So, we're gonna kind of do the same thing. We're gonna open it up. It's gonna be, I don't know, maybe a little more informal, I guess, where we'll take feedback from everybody on this settlement and Salt Creek project as well. So make sure you come out or share with your neighbors. And comments.
I'll just say as the highest paid microphone custodian, I will not be accepting tips today.
Who was out on?
You guys, I don't think it's time to talk.
Go ahead, Jen.
One other thing, just to, add to what Jim said, that is exactly true. Due to these proposed turbines, Fortiva has moved a significant amount of acres into Benton County as well as Grundy County. And you are taking from one of the largest pioneer seed corn plants right here in town. So if you want to talk about helping out the county and industry, you're taking from them.
Hey, Jen, go ahead, Ryan.
Okay, I think part of the I had told that you cannot go between these turbines, so there's more. So they're moving out where there's no turbines, so we are losing money because these companies are messing up our land, which they are. And I also say they lie to farmers, and I hate to say that. And they may not be the company, but the people who sells the company lies. My neighbor signed up and he keeps apologizing to me. He can't get out of it. He has a higher life. I wish he could. I really wish he could. But he surrounds me totally. And he farms my land. So, and he had a gag order. He couldn't talk to me because he told Rita I get sued. That is wrong. He's my neighbor. It's a freedom of speech. If a farmer wants to talk to another farmer, I think they have rights. But I told that you can't talk to each other. That is wrong.
Doug, go ahead.
I just want to ask, whether you're gonna run with your tail between your legs and afraid of being sued, or you're gonna stand up for what people of Tama County really want and need, and what's best interest for the majority of the farmers in Tama County.
All right, any other comments? Or,
I ran out of time earlier, so I'll just hit a few other things. I do believe, like I said last week, that the people that signed up for this did so with the understanding that the county would enforce the existing ordinances. Yes, they're from 2010, but they do exist. And there are some areas of that that are not currently being followed. And if this company is claiming that they're meeting those ordinances now when they're clearly not, what's to say that they'll say the same thing about following our ordinance in the future? If myself and someone else claim they're in violation and they just say, no, there's not. I mean, if they're not following the ordinances before the application, what's to say they'll follow them any better later? And whether or not you agree with this project, I hope we all believe that we do have ordinances that should be followed, and we want to follow the right process for doing this. And that includes submission requirements and the process that we have set up. And yes, Mr. Updegraff mentioned other counties do have supervisors approving these, but the majority of counties that do have both a wind ordinance and a board of adjustment have it going through the conditional use process. Yes, some counties don't have a board of adjustment, so their board of supervisors does have that in their ordinance to go through that. But most counties do have it listed as a conditional use process, and the conditional uses go through the board of adjustment. We're not alone on that island. I would like to just say again that, you know, our ordinance states that the applications to be reviewed by the BOA. I still don't feel that this agreement is beneficial to the county. And I would hope that you do take it to the Board of Adjustment for their review. And if it does end up going to a district court case, at least that'll be on the merits of our ordinance and our process, and not trying to go around it to settle or develop something that is outside of our ordinance at this time. And yes, you guys have the opportunity to change ordinances, but there's a process, including recommendations by the zoning board, multiple public hearings. This is not just we want to pass this now. This is a process that takes a while to get ordinances changed and updated. And if they want to wait for us to change and update our ordinances, then so be it, but let's not rush through this, please. again, I urge you to go through the Board of Adjustment for this instead of going through the Sullivan treatment. Thank you.
Thank you, Lady John. And John had his hand up before.
One final comment before I leave. My brother's father-in-law farms in Hardin County. You cannot find another place to put a windmill up in Hardin County. He owns land in Tama County. The cheapest property taxes he has is here. He's right here in Tama County. Now, let's be realistic. You think your property taxes are gonna go down? No. Can anybody tell me what goes down? It's not gonna happen. You think there's gonna be a school show back up in Gladbrook? No. Not gonna happen. But everybody thinks that these turbines are the second coming. Well, I'm gonna tell you, when those things go up, the county is holding the bag, and the people that live around them are as well. We have several friends in Hardin County. And it's open to everybody. Do your due diligence. Ask around. They said, don't make the same mistake we did. It's falling down. On the end of Main Street of Radcliffe, where my wife is from, the town gets to look at a pile of junk standing there. We thought it was leaking oil, but it had been on fire. They're all rusty. They're all losing their paint. Money's not everything. Money is not everything. And I asked the supervisors, don't sell out. These people, they're here and gone. And yeah, I like that about getting your tile fixed. Good luck with that when they're gone. I'd like to see that. But just keep in mind that you're taken from an agricultural industry here in town, let alone the farmers out there. We cannot take the land that we've been blessed with for granted. This is some of the best in the world. And we need to take care of it.
Hey, Sean, let's Karen was next, and I'll come back over here.
Yeah, I'm gonna mention a little bit of what John just said. So maybe a month ago, Kimberly was here, Salt Creek next year up Cedar Rapids, claiming that these things were gonna be paying out for 30 to 35 years because that's how long the contracts are. That's what she said. And I said to her when it was my term that the contracts are 30 to 35 years, which is what? I mean, none of us are gonna be alive. Maybe our kids will care, maybe not. Maybe our grandchildren will care. No, they won't care because 35 years is a long time. But I did tell her that these things don't last over 10 years, which she did not contest or correct. So we are destroying our agriculture, crops and land for a bunch of stuff, like John just said, a bunch of junk. It's going to be standing here when we're not standing here. It's our job to protect this land for our next generations down, but we're more than that. God is watching everything we're doing. And I always go back to that because we are here and he is watching and we better darn well do a good job with what we've been given. Land is our gift. And not very many people have land. And the ones that don't have it, well, they just found a way to take it.
Thanks, Karen. All right, gentleman in the back.
Yeah, I worked for Stormwater a few years ago and, took a pallet of salt up there. It's like Dysart. And it's northeast of Dysart, about 7 or 8 miles. Anyway, this guy had a big circuit. I mean, big. And so as I was loading the salt, I told the farmer, I said, hey, you're making money. He said, what do you mean? I said, you're middle turn out here making money. He said, I'll tell you what, you want that damn thing? He said, I've got a guy out here all the time trying to get that damn thing. There's something wrong with it all the time. And that was the same way with these Alliant Energy guys. I talked to them too.
He said they're just very high maintenance, and I don't see where the money is made from those things at all. And how that can be, like you say, oils, bearings, and those things can't just sit there because the wind's not blowing. Because like bearings, they'll have a tendency to flatten out. In fact, the turbine has to turn a little bit all the time, even the wind is not blowing. So there's a lot of things into these things that people don't understand. That's it.
Well, I just want to make a comment. Does anybody know if that place of Marengo failed that was grinding up blades? I don't see any vehicles there now. You go by there and there's still all kinds of junk behind their building. And also, my knowledge, there's no landfill in this state that wants any of that stuff that you're talking about, junk. Our landfill,
Said no.
we put it in our bylaws not to accept.
I heard that the EPA shut down that plant in Marengo.
Well, what I want to
Because the
fiberglass dust.
yeah, they weren't controlling the dust.
I heard that.
All right, we got one comment in the back here. Please state your name.
Yeah, I'm Doug Roberts of the southeast of Darwin. Kind of got a background in engineering, so I do a lot of calculating, kind of like engineering. And one of the things, I think a perspective needs to be mentioned. How many of you enjoy watching the flights go over the front? Everybody, confidence get railed, across the Iowa.
Yeah.
In fact, you can even track on the computer to see where those flights are coming from, and where they're going. Every one of those windows that goes up only has, it generates enough power in a whole year for the equivalent of what 5 strands of land in the transcontinental gas. So basically, you see 5 jets go over, you say, gosh, that windmill is sitting there turning for a whole year. It's only putting out as much energy as 5 transcontinental flights. So are we really talking about a significant problem? That's my question. And I'd like to think windmills are going to be, do the thing and give us electricity, but compared to the amount of energy that it requires for us to run this country, it's a drop in the bucket. It's peanuts. Every time you see 5 flights go over on a nice clear summer evening, assuming they're transcontinental, which are most from New York, Boston, to Los Angeles, Seattle. Just think about 5 of those is the amount of energy that one of those turbines produces for you. Something to think about.
I have something.
One last thing on it. Yep. So really the issue, when you get over to the environmental side is, what's that carbon dioxide coming out of the dead leaves? How is that gonna get sequestered back in soil? This is the only place it can go, right? Or you put a pipeline on, or you jam it over, put it in some old gas field, but you're home. It's a big issue. It's keep everything in perspective here in terms of really what the issues are.
Thank you. Rita?
Okay. In our paper. Like that's fire. It'll just go either.
We're bringing the light, Rita. We can't hear you up there.
Yeah.
I've been reading paper. Good morning, figure out it's whatever. Oh, okay. That wind turbines can't catch on fire, not have any buildings that we or not. Well, that will affect the crops, and that will affect, your industry and also the debris that the wind turbines will have on the ground. This one farmer, I guess he's suing the company because they refused to clean up the mess. So, last time I read that they were in court because it's turbine caught on fire. That's the thing. They're run by oil. It's a 50-50 chance. Maybe not a lot, but they're always going to be paid that something will happen. And also there's occasion that the blades will fall off. occasion that the mechanically it does not work. It's a machine. Everything breaks eventually in time. Are they gonna come and fix it? My question. And they're gonna leave not knowing what's going on. Now, they're giving you a bill and we're stuck what we have. And do we have to go to court to have them repair it or take it down or decommission it? I think number one, we need to put standards in our ordinance. What we need to do. Number two, I think that no wind turbine should be on ground that's higher than 60 to 75, because that's good ag ground for crops. We're the ones to be the not the wind turbines. Who's gonna feed the people? The more land we take out commission, the more land we take out production, it's the less land we're gonna feed this world. If we can give away a land, what's gonna happen? Think about it. It's not happening now, but it will in the future. Thank you.
Thanks, Rick.
I guess I'm next, but anyway, what I want to say about this, electricity thing, I kind of deal with electricity quite a bit, but anyway, what I'm trying to say is, as far as being, short of electricity, you know, we're getting more efficient with our lighting, the LEDs. We've got the electric motors that are more efficient.
Yeah.
And there's a lot of things that just say you have a two-phase motor, it'll probably draw 20 amps. So if you have a three-phase motor, which you have to have three-phase, so you're drawing less amperage, which is less wattage. So what I'm saying is that as far as the efficiency of everything that's going to incorporate into these products, I mean, I think that we've got plenty of electricity. I don't think we need to have limits. That's my take.
All right, thank you. Anybody else, final comments? I know it's been a long meeting. Okay, we'll be adjourned at 11:06. Thank you, everybody, for showing up and speaking today.